Hello, how are you everyone? Hope you are guys are well. By the title, I hope that you guys understand which topic what I'm talking about. So today I will talk with you about the Houston Maritime Injury Lawyers. So here there is a website. From there I will give you some knowledge about this topic. So at the Patrick Daniel Law, our Austin maritime lawyers are well equipped and handle difficult maritime injury cases that other Austin maritime law firms find too complex. Austin maritime injury law, also known as a admiralty law, has a lots of quirks and inconsistencies. It takes an experienced maritime injury attorney to be able to see these inconsistencies, and we find them every case that makes it to our Houston law office. Houston maritime workers are at a disadvantage in some maritime cases. In other maritime injury cases, they have some advantages in their favor, but only a skilled Houston maritime attorney will be able to figure it out. So whether you are in Houston, Harris County, Pasadena, Wayton, or the outlying suburbs, if you have been injured at sea and are in need of a Houston Maritime Injury Authority, Patrick's Daniel Law is here to help. Contact our Houston Maritime Laws for a free consultations. Here they have given some pictures, and by the pictures we can understand. This is a law where if you injure it by an accident, they will not complete your health, but they can help you by the money or by the financial support. And in this law, they will always be with you to helping you to come over from the problems by the money, and nobody can bring your health back, but some of the problems from the money, they can solve it easily. So here this law says about they will help you by the money or any other things. So Patrick Daniel is an icon among Houston maritime attorneys, gaining the distinctions through 20 years of maritime laws in Houston, Texas, and around of Gulf coasts. Patrick Daniel has argued maritime injury cases from both sides and has extensive experience not only in the way Houston maritime laws cases produced, but also in the work that goes on the seas by employees of hundreds of Houston maritime companies. Here is a short list of types of Houston maritime injury cases he has handled in both Texas and elsewhere. So here they mentioned some list of the Houston maritime injury case, and we will see what is written in there. Jack up rig accidents. They will be with you if you are jack up rig accidents, dig accidents, tugboat accidents, oil platform accidents, barge accidents, commercial fishing accidents, cargo ship accidents, shipyard accidents. There are 1, 2, 3, 4, 5, 6, 7. There are some 7 short list of hosted maritime injury case, and they will be help you by these topics or by these problems. If you sustained a maritime injury in Houston similar to above and would like to free consultations with our Houston maritime lawyers, or to find out more about Houston Maritime Law Service, please call. So they have mentioned below the number that if you have any query or you have any question about their services, then we can call them freely by this call, like 713-999-6666. Or we can contact with them by online to contact us. Okay. So we will get knowledge about the Houston Maritime Law. Houston is much more than oil and aerospace. A recent study showed that Houston, Texas is the #2 city in the country for jobs connected to maritime through the moving of cargo between US ports. Only nearby New Orleans has more workers in the maritime industry. When you add up the workers from all Texas ports, it puts Texas as the #3 state in the US in cargo transportation between American ports. The port hosted includes over 200 private and public terminals, handling over 8,200 seagoing vessels and 2,15,000 birds every year. Thousands of maritime employees call the Austin area home. It should come as no surprise then that there are a multitude or maritime injury case in Austin. Maritime workers who are injured at sea do not have many of the resources that land-based workers do, and often have a hire to maritime injury lawyer in Austin to protect their right and help them recover losses that stem from their maritime injury. So here they have mentioned that I told you before in this line, they have mentioned they will help you or they will help you to recover your financial problems or what you loses from this accident. They will recover your loss by this Austin maritime injury. Austin maritime authorities, Austin maritime lawyers are plentiful and they know admiralty law inside out, but experience is key. As an elite maritime injury lawyer, founder Patrick Daniel has litigated hundreds of maritime injury cases and has substantial recoveries for his clients. But this process requires more than a successful county room attorney. Maritime work is grueling, unforgiving, and raw. And any Austin, Texas lawyer who aspires to present maritime workers had better know the work as well as he knows the law. That's what sets Patrick's Daniel Law ahead for other law firm in Austin, Texas. He knows the work. He grew in the Louisiana and has 20 years experience in litigating maritime cases, some of it the other sides of the courtroom. Working at sea is different world out there. This is a very nice title. Working at sea, it's a different world out there. If you work in a sea, you will see a different world, because in the sea, we see the things or the planets that is not in the outsides of seas. It is only on the seas, like fishes or many other things which are only lived in water or sea. So if you work in a sea, that will be very enjoyable for you by working with a seaside. Okay, let's talk about the topics. We are not going through another topic. There are literally hundreds of maritime companies in Austin, and even though they claim to appreciate their employees and the sacrifices they make, you are only one fall on slippery deck or one tumbling plate of cargo in heavy seas from discovering how much or how little they truly do care. If you are injured in sea, don't assume your employer will compensate you fairly and make sure your medical bills are covered. Anyone of a host and Austin maritime lawyer will quickly point out that the bail game changed drastically when an injury occurs. Not only that, but the rules are different for maritime employees and land-based employees. Defendants in maritime law cases try to hide behind the nuance of maritime law, hoping the injury part is not up speed on them. For instance, workman's comp does not apply to injuries suffered while at sea, but thanks to the Federal Jones Act, maritime workers have the ability to sue their employees for compensations and employers and held accountable to provide reasonably safe working conditions and to maintain their vessels so they are safe and seaworthy. Maritime law and admiralty law are same thing. Maritime law and admiralty law are same thing. Yes, let's see, is it right or wrong? So what does maritime means anyway? What time maritime means anyway? Literary. Maritime regards anything connected with the sea. So maritime regards anything connected with the sea. So if you are connected with sea or if you are enjoyed with the sea, the maritime will be affected. Maritime will be appreciable. Without the sea's problem, without the injury of sea, the maritime will be not appreciable. Okay. This can be applied to commercial shipping and transporting or military activity. This maritime will only you can apply for commercial shipping. If you are buying products from China to Bangladesh, this is a commercial shipping because you are buying a product from China and you are collecting it in Bangladesh. So it is a commercial shipping and transporting or military activity. We know that military activities, the militaries are run in the or see like they work or they round on the seas. And if they faces some problems, then that the maritime laws will applied. The series of laws governing maritime activities are known as admiralty law, a term used interchangeably with maritime laws. Maritime law does differ from the law of sea, which governs international trade, mineral rights, jurisdictions over coastal waters, treaties and relations between countries. Admiralty cases are more local and concept, involving civil suits, individuals, companies, and representatives of those companies. Types of maritime injury claims. Here's the pictures, and they have mentioned some types of maritime injury claims. Like maritime workers face situations and endure conditions that would send most land lubbers into a state to fear and despair. While for the most part they understand the hazards and have various ways of coping and minimizing the risks, accidents do happen. Like slip and falls. Solidly number one injury claims in wet conditions, slips are common and stairwells, digs, and even in crew areas. Bumps and collisions. Swinging bombs, tanks, dollies, cats, machines, and unsecured cargo can bash into workers. Lifting and carrying mishaps. A tightening dig or rolling seas can make lifting heavy objects and treacherous. Even under ideal conditions, heavy lifting is a risky endeavor. Illness. Not every claim is due to an injury. Sometimes crew members becomes ill due unsanitary conditions and improper food preparations. They become illness for their food preparations, for their food poisoning. Okay. When to call maritime lawyer? You can call, what is the sure time to call a maritime lawyer? They have mentioned in there, we will understand what is the sure time to call the maritime lawyer. The quick answer to the question of when you should call a lawyer after an accident at sea is as soon as you ship dock in Austin. If you have cell phone, Wi-Fi access, and the privilege of making personal phone calls on board, call or contact an authority as soon as you can. If your ship allows workers to make personal calls, the management cannot take action against you if you use your time to call an authority. So here they mentioned that what is time to call the maritime lawyers if you are in a problem. So they said that if you are in problem, then you can call them for helping, or if you have a cell phone, that is good to call them, or that is very good for to calling the maritime lawyer. So they said that if there is a problem with the ships on the road or on the sea, then please call them for helping or to get support from them. A common mistake some workers make in trying to appear to be a calm player who does not want to stir things up with the threat of lawsuits. There could be a quite of a price to pay in order to protect an image that won't even benefit you in the long run. A lot of Austrian maritime workers or farmer workers who can't work anymore wish they had called an authority promptly after their accident. Don't try to determine by yourself if you have a case worth filling, despite all the blogs and websites that try to advise you on a die courtroom strategy. Make the smart move and call an attorney. Patrick Daniel has won so many admiralty courts that he can generally recognize a winnable case in just the first few minutes of a pre-consultation. If Patrick Daniel Law accepts your case, the legal fee will come out of the final statement and you will have no out-of-pocket expense. The Merchant Marine Act Jones of 1920. Once you sail out of Austin and leave the national boundaries of the United States, even if you are a U.S. citizen employee by a U.S.-based company on a ship registered in the U.S., some laws designed for your protection no longer apply. Unfortunately, other laws moves onto play to restore some of these protections, but in the different manner. One such law of Merchant Marine Act, it is an expensive law that includes regulations governing maritime commerce in U.S. waters between U.S. ports. Section 27 of the Merchant Marine Act, known as the Jones Act, requires that commerce between U.S. ports and transported only by American-built vessels. The Merchant Marine Act, the Jones Act are often more used synonymously, but in actual, the Jones Act is a part of Merchant Marine Act. The Jones Act also includes provisions that have seafaring workers' right at their core. Those provisions includes, among many others, the owner of the vessels must use reasonable care of maintaining it for safety and seaworthiness. The owner can be fined liable if it is found negligent and negligence led to an injury. Qualifying sailors as like officially classified as seamen who have suffered injuries in illness while at the sea can recover appropriate compensations from their employees by lawsuit or if necessary. The notion of vessels seaworthiness is extremely important as it can move a case from one where the best outcome would be the recovery of basic expenses as like a skull maintenance and cure to one where all of the victims' losses are recoverable. What is a seaman? So we will get understand what the meaning of seaman or what is a seaman. So the major provisions of the Jones Act apply to special class of worker class called seamen. The major provisions of the Jones Act apply to a special class of worker called a seaman. It is legal recognitions that and very important to the process when injury claims are filed. But there are no building definitions of a seaman anywhere in the Jones Act or the Merchant Marine Act. There are a precedent, however, and maritime attorneys for both sides have the short thought past cases to determine if the plaintiff qualifies as a seaman. Simply being employed by one of the Austin's many shipping companies and spending times out at sea working that job is not enough to qualify as a seaman. In lieu of legal definitions, most maritime lawyers and judges typically agree to one of the following definitions, but the definitions has undergone to metamorphosis of terminology over the years, and it is still subject of revisions. So here is the quotations is in a source. So the quotation is seaman means an individual. Seaman means an individual means alone individual. Seaman means an individual. Expect significant personnel and selling school instructor or selling school student. Engaged or employed in any capacity of board of vessels. So this is a very nice quotations. I have to appreciate this quotation. Very nice and very deep meaning of this quotation. That is nice and tidy and refinement of more cumbersome definitions that preceded it. But the Jones Act sets progress back a set, inciting that to qualify as a seaman, a worker must spend at least 30% of his or her time on board out at sea. So if you are a seaman, if you want to be a seaman, you have to be a worker, or you have to be spend 30% of her or his time on board. 30% of his time. Then he or she can call a seaman. It is a point upon which the opposing sides in an admiralty case can argue that for hours without an overarching definitions to go by. However, it often becomes a stumbling block of the process. Okay, so we will see if you don't qualify as a seaman. So if you are not qualified as a seaman, then what to do? Longshore and Harbor Workers Compensations Act. Workers who don't satisfy the terms for the definitions of a seaman can still recover damages from the longshores and harbors workers compensations. The federal law allows the injury party to recover losses of medical expenses, lost wages, rehab, etc. due to an injury, as well as supervisor or survivor benefits if the injury caused the worker's death. This covers dock workers, ship builders, and harbor constructions workers who were injured in the wharf area of the harbor. The provisions of LWHCA differ. Some standard workmen comp law and generally provides for slightly better compensation. So we will see about the making a case for negligence. Without the safety net or workers' comp, maritime employees often have to relay the provisions of the Jones Act, the compensations. In a few ways, maritime works actually have better subsystem at their disposal, which is why contacting of a maritime injury laws of utmost important when injury has occurred. With the provision of the Jones Act and rely upon maritime workers can file negligence lawsuits that go beyond the standard maintenance and cure the certain types of injuries. They can receive a more substantial settlement when they file negligence suit and only have a proof that the employee's negligence merely contributed the injury in some ways. In the other words, the negligence does not have to be the entire reasons for the injury. It can be actually play some small role of the relevant. Employers can contend that many times workers must acknowledge the substantial inherent risks of workers aboard a sea-going vessels, but it doesn't absolve the workers of ship owner and liability when something goes wrong. Employees are accepted to build and maintain and ship to code, make repairs and needed and improve the safe workers environment. Reasonable care most of the exercised and they must forces potential of mishaps and take steps of eliminate them. Negligence of is not limited to the way the ship and maintained. Sometimes decisions that put workers at unreasonable risks must be held and accountable, requiring workers to perform tasks as unsafe area, conditions, forego and safety products, uh, perform tasks for which they have not been trained or to state from the accepted passions regarding seagoing cargo are just a few examples of conduct that can be considered negligent. Here we will see the types of maritime injuries cases. So here some cases they have written. So at first I would like to say about the maritime workers face situations and endure conditions that would send most landlubbers into a state of fear and despair. While for the most part of the understand and hazard text, they exposed to have various ways to coping from them and minimizing the risks accident and to do happens. Among the most common injury proceeding accidents suffering by machines and unsecured cargo when bashed into workers. Uh, there is also an slip and falls. Solution number one in case claims weight condition slips are common and occur in a stairwells and decks, even in the crew area. Lifting and carrying mishaps at tightening deck and rolling seas can make lifting heavy object treacherous even under ideal condition and heavy lifting in risky endeavor. Illness. So illness not even claim is due to injury. Sometimes crew members becomes ill due to the unstable condition of an improper food preparation. When the ship is out of the sea and injured workers, only medical options is onboard medical staff, also known as a in pharmacy or sick bay. They can be a real asset of pose a risk if a personnel are inadequately trained. In extreme case, a transport helicopter might be needed, but weather and sea conditions can apply a role of whether helicopters can be disachieved. Filling your maritime claims the don'ts. An injury at the sea almost always breaking news around the ship. It's impossible to keep something like that a secret, but regardless to the severity of injury or the manners in which of occurred, it's vital to maintain a gaps on the facts because ultimately it is up to set records stand on what happened as word of your injury reaches management that will be naturally want to talk to you. Be very careful of what you say if anything. While you don't want to be rude and uncooperative, do you have must protect your intention. And by all means, do not submit or recorded statement. You cannot be compelled to provide a recorded statement at any point of the progress. Your compositions, if you decided to contact a maritime lawyer and file a claim, you will be tired directed to the degree of which employer or ship owner neglect. Insurance company adjuster and the attorney of their sides are masters of manipulate. And anything you say prior of case going to court can be twisted and used against you. Don't think you can outfox of a season pro. Don't sign any documents, approve any settlement offers and sign any statement without consulting a maritime attorney. Feeling your sorry Fillings your maritime claims that do, however, fill out an accident report as part of the claims process. The difference here is when you fill out the accident report and you are in control, you have to time and ponder your answers and clearly establish the facts without being put on the spot trying to answer trick questions. Get the names of any co-workers and witness who saw the accident and perhaps even notice a hazard that might have contributed to your injury. Contact Daniel Patrick's Law and Austin immediately. They will go over your case and help you with the accident support and help establish a conscious hypnosis and accident. Based on the confidential information you provide them, they can advise you if your case is likely to successful, and if so, advise how much compositions and you might be entered to. Things change when you hire a maritime authority. The density of business is awesome, especially the business in the maritime industry creates a community where the information makes and rounds and pretty quickly. When on a one of the companies like taken to court in a maritime injury suits and the other companies in the Austin areas takes notice. Frankly, neither sides in maritime injury case wants to matter to go to court. Many don't, fact, most don't, and often. When a maritime lawyer enters the case of the sea side and victim, the opposition the suddenly decided is their best interested to settle out the court. The entire sign here will be done with this offer and offered withdraw and replaced with something that you must establish and fair. Intimidation and technology generally subside, and for the most part, they will leave you alone and deal with you authority directly. Do not attempt an interior and maritime injury claims yourself. Maritime laws differs widely and from that kind of law and you might be familiar with. It's also it consists of state of plaques and the Martian Marine and Code of the Jones Act like have and reversed and multiple times and since their inscriptions. And there are sets of right now on for new revisions and for the event calls and repair. Maritime laws FAQs are the what is considering maritime, what is maritime injury. So we will see about the what is considering maritime work. A wide range of different jobs and may consist in maritime employment, and many of these jobs and meet the legal definition of a seaman and under the Jones Act. And there are some there are therefore entities and workers to maintain the core of the bring claims and in negligence and in the event of the injury. There are some points of that and we will see what the points are. This the captain of a ship, the ship's crew including the clans and engineers, pilots and officers, etc., fishermen, berg workers, commercial divers and cruises and employees of shops and well workers. Maritime works also take places to areas adjoining negatively waters and including harbors, piers, and what's the seapiers and etc. However, if you are injured which while working with a long shores and ship builders or another job that doesn't meet the legal definition of a seaman, and you will need to be turned into the longshore on the Harbor Workers and Compositions Acts. We'll see the what is the maritime injury. Maritime injuries and types of harm and befalls and somewhere working on the adjoining and negative waters and United States. Many different situations it can be lead and maritime injuries, including like shipping from the front of the surface, being stuck with by the swimming yard and bombs and other machinery and implements, injuries of the back, shoulders and extremities and moving heavy claps and heavy equipment of the cargoes falling from the workers, fires and explosions and cranks and collaborations and cements falling overboard, exposure toxic chemicals and materials. These and other accidents can be happen for the seafaring vessels at the port, at the oil rigs, and anywhere else that maritime workers and performed. Maritime workers and enter the compensations of the injury and the sustained and job, but the produce or failing of the complaint and differ from the what does in landlocked and professionals. Um, so here's some laws of the maritime, like example causes and how does your maritime case compare. Despite with the thousands of the maritime injury causes involving ocean based and maritime farms and their employees, and there's always something the new that comes along. The following cases from the around the US and presidents and the similar cases of the flaw. American seafoods and owner of the ship and American businesses and found of the negligence and not privileging safe and worker environment for the crane operations who fall trying to reach a control and should be having more executable. The workers has required by his supervisors and operate a midship crane on the toll deck. Normally, the crane could be operated by the wireless and remote control, which allows workers to use the crane during the entire claim and weather. However, on the day of the accident, the remote control was not available and having been taken off the surface with the shift of the engineering and the crew wouldn't be misplaced. In the order of the use of the crane and the workers had a claim to leader and reached the control tower. The leader was substandard and even written company which processes and assesses the leader and have spaced and the ranks. The ladder and did not have the evenly spaced and the running at the fall and faced from the serious skin knee injury. The case was now on the base of the ladder and that didn't meet even the company written safety policies. The judgment and was the $9,000. Uh, Mitchell v. Throwers and Racers said about 1960 that in the case went all the way of the US Supreme Court and established for the modern precedent of what consists in seaworthiness and reasonable care. Frank C. Mythical ship and stairway abroad the fishing towel and racer when encountered slim on the handland. He sued on the basis of the negligence and of the ship's underwaterlessness. The ship towers and owner said the condition of the handwell and was known as the crew as was temporary and the reasonable for had been applied for the maintenance of the vessels. A jury cites and the both practice and allows the Mitchell and the collect on the standard maintenance of the cure negligence. As the provided of the Jones Act and but the ruling of the defendant of the charge of the use unseaworthiness, Michael appealed to the role charging and the presiding judge was the error when he instructed the jury that order of rule and plaintiff patience and unseaworthlessness. The defendant and had and have known about the slave of the handle and chosen not to address it. The appellated court sides with a lower court based on the presumptions the plaintiff and failed to prove the ship's crew knew about the slave beforehand. But when the case eventually reached the US Supreme Court, the case was overturned. In written an option of the court, Associate Judge Porter and Sweater says that the ship owners reasonability and provide like seaworthy and vessels goes beyond the simple applying reasonable care and that temporary conditions and that readers and vessels unworthy does not relieve the owner's liability. Uh, Graduability and secure lock marine in INC 1995. Here they're saying that the graduates and was survivally injured when a manual crack and handle of the field had a laid on the top of the electric winds and flow of the which when the which suddenly activated. He had been using many manual crank and fee with the winch, and which is the become the stuck, and the crank handle stuck and graduate sticks in the eye and face. Graduatex and sway secure lock main is negligence of the secure of the provides worthy and vessel, saying the head have been properly trained in the use of the manual crank and secure lock counted, saying graduatex have been thoroughly trained on the towboat and rock lane where the accident occurred and had been trained specifically on the use of the manual wind cage, and the said should have the exercise better care for his own safety. According to the Jones Act, a Siemens needs exercise on the slight care of his own safety, while his employer is had a much higher standard and assume a safe work environment. Secure Lock Authority argues that the court had blindly followed an incorrect statement of the law. The court said that regardless of the correctness and fairness of the side care provisions of the Jones Act, it could not alter it, adding that it would be up to higher courts of change and interpretations of the law and lawmakers and change the laws itself. The jury apportioned a 95 of the phone and secure lock and 5% grotulax and awarded him $854,000. The figure was later reduced by an appeal judge to $763,925. Experience and maritime lawyer in Austin. So here we will see the experience and maritime see, and there is also they've given a video on this. We will not open the video because we don't have much time, because the videos may also so longer, so we will stop our videos as well as early. So in the case examples above, you live and scratching your head and you are not alone. Maritime laws is a complicated and subject of various interpretations and subject of the reversions. Your choice for the resolving your maritime injury cases and practice Daniel laws and practice Daniel standard on the working of the maritime injuries cases from the defense sides. He cut his teeth and learning the tricks of the maritime negligence and defenses, concealing and evidence of the witness and dealing tactics and settlementing in the individual. 20 years ago, he switches over the painful and side of the maritime law and has become a passionate and advocate for those suffering from the maritime injuries. He is not only a master craftsman in the courtroom and negotiations of the table and the expert of the authority, but he also known as the work. He is Lucians and native and grow up around the people of the marine industry. He is even represented people work and other contentious and self high seas and including offshores and right. Jacob writes and dealing drugs and encore handling vessels and towards the crew of the boat and more. You won't be able to prepare and practice with the maritime venues and with the neither will those of on the other side and the courtroom. Patrick's Daniel laws and practice is not only limited to the Austin, Texas, or the even the Gulf of the Coastes. He has been claimed in the Legias and Mississippi, you know, it's a river or the huge river, Mississippi. This name is very easily, and I heard it in my book when I studied. And the Mississippi River is very known river, yeah, and the Florida and as far as a way of North Colonia. Conduct practical and Daniel laws of the free consultation. If you have any winnable and maritime case, you will tell at us. Don't if you don't know, well, tell you what's as well. We charge no fee until your maritime injury cases have been on or your behalf. Don't let an uncorruptible companies and ship owner avoid the obligations of the pay of our losses. So there's the their option they said, as like I would like to say, just like in any other industries, semen is a risk of suffering work and related injuries at the any time of they are on the clock. The code recognizes this at the continuously and working with the protect and injury assessment through the general maritime laws, and maritime laws gives workers to have been injured and offshore of the maritime laws, and often maritime laws and okay, going maritime laws and gives workers who have been injured and offshore of the maritime industry as a chance to claim uh, to change to claim their maritime industry at the necessary consultations of the any suffering of the medical complementants. Like general maritime laws at the base of the injury substances by seamen, it is important have to be a comprehensive understanding of the general laws and before believing in the subsequent acts. So that is all for the topic which I studied or I prepared for you, the Austrian Maritime Injury Lawyer. So that's all for the video. So if you like my video, please give a thumbs up and subscribe my channel and let me know which videos you would like to hear from me. Thank you guys. Have a nice day.